Just gonna wait a few minutes before I get started. Okay, can you guys hear me out there? I'm not sure if my microphone is working. This is my first time doing a live broadcast, so I'm just not sure. Okay, I'm just going to go ahead. Okay, great. Thank you, Jessica, for letting me know that you can hear me. Okay, I'm going to go ahead and get started. Today is the first broadcast, Facebook Live broadcast I've done before. I've done some pre-shot videos that I've shared on our page and our YouTube page. So this is new for me today. So I just want to thank you guys for tuning in. I'm going to get started by introducing myself. I am Joy Farrell, the founding and managing attorney here at the Farrell firm. I started the firm a little over 5 years ago. Prior to starting the Farrell firm, I was working at another firm right out of law school. I've always been a passionate person and a very hard worker. So once I kind of got into the industry, I realized there was a big disservice in treatment of clients that was happening, and I knew I needed to create something different. So with that, the Farrell firm was created, and I created the firm on 4 core principles that we here in the office call the Farrell 4. These principles are service, knowledge, quality, and results. You can read all about those principles on our website at farrellfirm.com. With these principles, I have been able to build a firm where clients come first, and a firm in which I believe, and a lot of our clients believe, is second to none. I can literally go on and on and on about how we do things here at the Farrell firm and what sets us apart from other firms in Atlanta and other firms in the country. But I'm going to save that for another day, because I know that you came here today to tune in to learn about understanding child custody. So before I get going into child custody, State Bar Georgia requires me to give a little disclaimer anytime I am giving what they may perceive to be legal advice. So that's one thing about me. I am an attorney who follows the rules. I'm very ethical. Okay. So all the content today is given for informational purposes only. This information should not be construed as legal advice, and it does not create a lawyer-client relationship. Each case is unique and requires specific attention. Please make an appointment with an attorney, ideally the Farrell firm, if you are in need of advice. So let's go ahead and jump into why you came here today. So there are 2 types of custody in the state of Georgia. Most of the time, and by most, I mean about 95% of the time, when I sit down to meet with clients about custody, the first thing they say is, I want full custody. And I'm like, what does that mean? Full custody? What? So here's the thing. Full custody, the term full custody, is not a recognized custody term here in Georgia. So stop saying it and let me tell you what it is. The first type of custody we will deal with and discuss today is called legal custody. So type number 1 is legal custody. Legal custody determines the legal right that each parent has to their child. Legal custody is the right to make major decisions regarding 4 different categories. Those categories are medical, educational, religious, and extracurricular. Legal custody can be joint, which means that both parents share the legal custody rights. Legal custody can also be sole, meaning that only one parent has the rights to make legal decisions. Okay, we have some questions coming through, and I'm going to answer questions shortly. It looks like it's coming from somebody in my office. That's funny. Okay, so let's keep going about legal custody. So this means, for instance, that parents who have joint legal custody can both make decisions about a child's education, like deciding where the child is going to attend school. The parents with joint legal custody should both be listed on the child's school records and have access to the child at school and be able to schedule things like teacher conferences, attend counseling sessions with the child, meet with the teacher, no questions asked about that. If you share joint legal custody with the other parent, you need to make sure that parent is listed on school records. Like when you sign the child up, make sure that both parents are listed. Parents with joint legal custody can also decide about medical decisions for the child. Where will the child attend the doctor? What special treatments does the child need? Does the child need physical therapy, etc.? Parents with joint legal custody can also access the child's medical records and make health care decisions. So similar concepts with the other two categories, extracurricular and religious decisions. The parents decide on what activities the child will do and what religious beliefs the child will be raised to know. Joint legal custody works when you have two parents who know how to co-parent or have similar belief. However, lawmakers know that the likelihood of that may be rare, so joint legal custody does have some options. With joint legal custody, one parent may have the final say on some categories, say, for example, school and medical, and the other parent may have final say on other categories like religion and extracurricular. Or one parent could have three categories and one parent could have one category. One parent could have all four categories when it comes to making the final say. The law requires that the parents discuss these things regardless before making a decision, but in the event that there is a disagreement, the parent who is given what we call tie-breaking authority will make the final say. So, for example, let's say you have a child who you want to do soccer and dad wants the child to do football, and those seasons run at the same time in the same day, so you can't do both. So what are you going to do? So the parent who has the tie-breaking authority on the extracurricular activities will make the call as to whether the child is going to do soccer or football, but the parents should have a discussion about that before anything is decided. The specifics of your joint custody will be worked out in your custody order from the court. The next type of custody is one that most people are typically most concerned with because it determines where the child will actually live. This type of custody is called physical custody. Physical custody refers to which parent the child lives with. With physical custody, one parent may be given what we call primary physical custody, or the parents may share joint physical custody. A lot of times when people say full custody, I usually know they're trying to get to they're talking about physical custody as far as where the child is going to live. When a parent is granted primary physical custody, this means that the child lives with that parent the majority of the time, and the other parent has some type of visitation schedule set with the children on certain days. A common schedule is for the kids to be with the primary parent during the week and then spend alternating weekends with the other parent. However, some parents don't want to be just weekend parents, so there are other options that we could tailor to your specific lifestyle situation to make sure that you're spending the kind of time with the kids that you want to. Okay, parents who share joint physical custody have the children almost equally, sometimes exactly 50-50, or sometimes it's very close. It could be 45% of the time, 55% of the time. However, even with joint physical custody, it can be proper to still name a primary parent, either for school purposes or for tax purposes. The primary parent for school purposes means that the child will likely go to school in that parent's district. And not the other parent. So a lot of times the parents, if they live in two separate places, they kind of pick which parent is in the best school district, and then for school purposes, name that parent as primary. So when the child is registered for school, we'll know that the child is in the right district. For tax purposes, primary parent will be the parent claiming the child on taxes. The parents also could agree to alternate years on who claims the children each year. If they have multiple children, one parent claims some children and the other parent claims the other children on different years. When we look at going into a joint physical custody situation, I encourage parents to think long and hard about what's going to be best for their child. Yes, it is amazing that your child will get to spend equal time with both parents, but we also have to think about the lifestyle that's being created for that child. Some parents will elect the kids to go back and forth every other day. Some parents elect to have the kids 2 days at a time, and then they go to the other parent 2 days at a time. Some parents do every other week. Some people do half the year, etc. But regardless of what you're thinking about, you want to be mindful that you are creating what we refer to as a suitcase kid, which means that you create a kid who lives out of a suitcase. And that kid pretty much never gets to settle because of the frequency of going back and forth between both homes. And I encourage you to think about how you would feel if you had to pack a suitcase every other day and go stay here or there. But that's just something to always consider, is how your child will feel. Parents who live close to each other are more ideal for a joint physical custody situation, especially when the children are school age, versus parents who live far apart, because that means regardless of who the child is staying with, the child doesn't have to get up extraordinarily early to make it to school, can kind of keep the same schedule each and every day, regardless of which parent the child is with. So regardless of what type of custody you're seeking or what type of custody you agree to, the courts are always going to make a final determination on what is best for the children. We call this the best interest of the children standard. You'll hear that a lot if you're going through the family courts, best interest of the children, what's best for the child, what's best for the child. Excuse my phone ringing. We are doing business here at the Farrell Firm. Okay, so a little less known type of custody that's not really often referred to, but it is a plan that some of our clients choose to do, and we call that split custody. This means that if the parents have multiple children, and if they have, let's say you have 2 kids, and one parent takes one child and the other parent takes the other child primarily, so let's say daughter lives with mom primarily, son lives with dad primarily, we call that split parenting. And then the children would alternate weekends. So essentially the siblings would end up together each weekend. Every single weekend the siblings would be together, but they go back and forth between mom and dad's house. So there you have it. The 2 types of custody are legal and physical. So the next time you hear someone say they have joint legal custody and primary physical custody, you will know exactly what they mean. And this also means that we won't hear any more of the terms full custody, because we know that is not a valid description of custody here in Georgia. Now, there are so many more things to discuss about custody and what the court will look at in deciding on who gets custody, especially when there's a disagreement with parents or if we're doing a full trial, some type of litigation. But we're going to save that for another day. Next, I want to talk about who has rights to custody. And now I'm talking to my parents who have children with someone they are not married to and have never been married to. Before I hop to that, parents who are married and going through a divorce at the onset have equal rights. If you're married, you have equal rights. It doesn't matter if you leave and move out with the kids. The other parent can go get those kids from school, check them out from school. The other parent can do the same things that you can. A lot of times there's a misperception that the mom automatically has the rights or whatever, but that's not true. If you're married, mom and dad have equal rights. One parent cannot alienate the other parent. One parent cannot dictate when the other parent sees the children. That is a false concept that causes a lot of problems in the middle of divorce actions. So just know that if you are in the middle of a divorce, or if you're getting divorced, or if you're thinking about getting a divorce, the children, both parents have equal rights to the children. You can't call the police and say somebody took your kids, because it's not kidnapping when you're married or anything like that. So let's just be clear on that. So let's move on to talk about people who have kids with people they're not married to. And we call that legitimation. So a lot of times because here in Atlanta, we have a lot of different firms advertising, you know, if they're for men's rights or women's rights, etc. So people ask me all the time, it's one of the first questions I get, are you a father's rights firm or are you a mother's rights firm? And well, here's your answer. We're neither. We are a do what is right firm. We represent men and women equally. And at the end of the day, we aggressively pursue the desired outcome of our client, regardless of gender. So I don't care if you're the mom or the dad, as long as you have a case and I support your position, then I'm on your team, and that's the end of that. So with that being said, let's talk about legitimation. In the state of Georgia, a legitimation proceeding is required for any father who wishes to establish legal rights to a child born by a woman he was not married to. Legitimation can only be filed by the father. Only the father can file an action for legitimation. So moms, you can't come see me or any lawyer saying you want to file a legitimation action. It is not proper. A father must file this action if he wants rights to his children. And so a lot of times dads come in and they're confused as to why they aren't able to see their child or why they're having problems with the child's mother. And the first thing they say is, well, I signed the birth certificate. That has to mean something. Well, what that means is that you're acknowledging that you think you might be the dad, but signing the birth certificate does not give you any rights to your child. Let me be clear on that. Signing a birth certificate means nothing when it comes to the legal rights to your child. Signing a birth certificate simply acknowledges paternity, okay? Only paternity. Paternity is DNA, okay? You need to understand that even though you don't have any custody rights, child support can still be ordered, even if a father does not have legal rights. The other thing dads usually call me about is they say, hey, I'm paying child support, but I'm not allowed to see my child. The mom is being this and that and everything else. This is when I tell them about legitimation. So moms, you can get child support even if he doesn't file legitimation. If we waited for dads to pursue their actions so that you can get child support, we may never get child support. So the law will allow you to go ahead and pursue a child support action against a dad who has not asserted his rights. However, dads, if you're paying child support and you want to have a relationship with your children, you must file legitimation. There is no other way around it, point blank simple. So after I tell people about this thing called legitimation here in Georgia, I always get, well, why should I do that? Well, why should a dad legitimate and why should a mom want him to? Well, for one, the child will get to have two parents that are actively involved in their life. But on the legal side of it, and this is what I tell my moms of these kids, is that if a child is not legitimate, he or she cannot inherit from the father if something were to happen to the father. And there are a lot of fathers that have become deceased without legitimating their children, and the mother is left here spinning wheels trying to see if she can inherit anything from that estate for the benefit of her children, see if she can get Social Security checks for the benefit of her child. But if that child was not legitimate, in Georgia, we skip right over that child. That child is not a legal heir to the father, so you should think about that when it comes to legitimating your kids. Dads, you don't want to die and your kids be left with nothing. Moms, you don't want the dad to die and your kid not be considered under the law. So moms, unless the dad is a threat to the child, legitimation is likely okay. And dads, stop complaining that you can't see your kids if you aren't willing to take the legal steps to make sure you have that right. The choice is absolutely yours. Okay, so I got some questions that popped up on the screen. So I am going to see if, so here's one. How does legitimation impact child support arrangements? No arrangements, it doesn't impact it. Child support and custody rights are separate. You can be responsible for child support even if you don't have a legitimation in place. However, once you legitimate your child, and let's say you legitimate and you have joint physical custody, or you spend a lot of time with your children, you may be able to get what we call a parenting time deviation, meaning you can pay a little bit less child support because of the amount of time you spend with your child. Okay, here's a good question. This came from In My Office. So what if we get married after I have the baby? So great question. So if you have a baby with somebody and you then marry that woman, the child becomes automatically legitimated. You do not have to file legitimation if you marry her. That is one way to legitimate. 1, file a court action. 2, marry the mom. So that will solve that problem. Okay. This is from Tanisha. What if the non-custodian parent lives in a different state? So, Tanisha, if the non-custodial parent lives in a different state, and you say non-custodial, so I'm assuming there may already be custody rights here. If they're not, if you and the child live in Georgia, then any custody action will have to be brought in the state of Georgia. So he would have to come to Georgia, file an action here in the county that you live in, and go from there. If you guys already have some type of custody and visitation and he lives out of state, depending on who did your visitation stuff or if you did it your own, you might need to modify visitation and come up with a plan that's more appropriate for parents who live out of state. And so in those type of situations, we're looking for visitation plans where children have long periods of time to go out of state. So fall break, spring break, summer breaks, part of Christmas break, anytime where there's multiple days off from school where they can travel to see the other parent and then come back in time for school. That's what we'll be looking at on a long distance parenting plan. Here's a question from Jennifer. When does primary physical custody have to be determined? Is there an age at which this must be determined? Primary physical custody is typically determined during a custody action or a divorce action. If it's not determined and it needs to be determined, you can always modify to request that determination if there's an issue with schooling or something like that. As far as taxes, if it's not determined, the person who makes the less money is deemed the person who can claim the taxes, children on the taxes. I hope that answers your question. Here we have a question from Hannah. What if you want 50-50 custody where parents have week on, week off? Is this considered joint custody, and does one parent still get child support? That's a great question. A lot of times people say they want joint physical custody and they don't necessarily want to actually have the child that long, but they want to avoid paying child support. However, just because you share 50-50 custody does not alleviate the child support obligation. There's a possibility that it can, especially if the parents are similarly situated financially, but if one parent earns substantially more than the other, that parent could still end up owing a little bit of money to the other parent just to make it equal. Okay, I'm looking for additional questions here. Okay, here's one from In My Office again. If parties agree to joint physical custody, does that always happen? No, it does not always happen because, like I mentioned, that best interest of the child standard, you can present an agreement to the court, but the court does not have to accept your agreement. The court is going to be looking at what's best for that child. So if you come up with a joint physical custody, it doesn't really make sense, and the court sees that it doesn't make sense, then they can actually deny that if they feel that it's not good for the children. Okay, we have from Zalove, does this include DNA tests with legitimizing? So DNA tests are not mandatory with legitimation. However, if you come through my office, I always recommend a DNA test, and depending on which judge you go before, they also will make you do a DNA test, because too many times, for some reason, people feel like getting DNA tests will hurt somebody's feelings, but it's always good to just know for sure. So we always request a DNA test when we file petitions for legitimation. If those results come back positive, we move forward with legitimation. And we have had several times where they actually come back negative. And in that case, we dismiss the legitimation and we cancel out any child support orders that have been put in place. So DNA tests are very important. This is from Tamara or Tamara. What happens if parents live in different county? How would shared custody work? It becomes more difficult, honestly. I mean, depending on which county. So let's say you live in a county like Gwinnett County, which is huge. You could live up in Beaufort. And let's say dad lives in DeKalb County in Lithonia. I mean, that's at least an hour apart in traffic. And that's not really realistic when it comes to transporting children, unless one parent has a very flexible schedule in transporting that child to and from school. So let's say the children go to school in Beaufort, school starts at 8 a.m. They spent the night in Lithonia and they need to be in Beaufort by 8 a.m. Like, how early are they having to get up, get on the road, spend time in traffic just to make it to school on time? Whereas if they were just to be at mom's house, they could get up at 7:15 and probably get on the bus and make it to school on time. So that's definitely something to consider. If parents don't own houses, I always encourage them, hey, move closer to each other if you have that flexibility, if it's really about the kids, okay? So this is from Jerron Martin. Is child support in Georgia supposed to be based off a actual income during the time of a hearing, or what the judge thinks you should be making? Okay, Jerron's jumped over to child support today, and we are going to do a video about that, but I'm going to answer this question. Child support is based on gross income. However, if a parent is not earning sufficient income, meaning you could be making more money, the court could impute your income to what your earning potential is. So, for example, if you have a college degree, if you have a master's degree, if you have work experience and you traditionally made $40,000 and now you're coming to the court saying, oh, I'm unemployed or I only make $20,000, the court may say, well, based on your background, your experience and your degree, you should be making $40,000, and they'll calculate child support using the $40,000 per year income. That's why it'll be really important for you to hire a lawyer to argue your position as to why or why not that number should be increased or decreased that they're using to calculate child support. How does custody work in regards to step parents? Good question. Step parents don't have any rights to children that are of another marriage. The step parent can, of course, be involved with taking care of the child and picking up the child, but a step parent doesn't have any say over a biological parent. If a step parent wants any rights to a child, they should consider doing a step parent adoption. The only way a step parent adoption would go through if the other parent is willing to terminate their rights or qualifies to have their rights terminated. Christopher Sanders says, how does alienation affect a child custody case? If it affects it a lot, Christopher, because the court does not smile upon alienation. It's never good to alienate a child from the other parent. So if that's been happening, then that's something that we would address with the court. However, we have to remember, we have to look at our starting basis here. If you haven't legitimated your children, then you don't have any rights to be alienated from at this time. And so that's why we want to start the process to make sure you get the rights that you need so that alienation is not an option. If there's no legitimation in place right now, the mom technically isn't doing any wrongdoing, but we can definitely put the argument before the court that she doesn't foster a co-parent relationship, and without intervention from the court, you won't have that. And so because of that, you should have whatever custody rights it is you're pursuing. Okay, got some more questions coming in, I think. Okay. Robert, can a mother protest legitimation? Absolutely. Legitimation isn't guaranteed. We also represent mothers against legitimation cases if we find there's a reason why a child should not be legitimated. Our biggest argument, honestly, that we make is that sometimes dads wait too long. For the legitimation law in Georgia, there's an opportunity interest, meaning you have a time frame to pursue rights to your child. And if you waive that opportunity interest, you may never get rights to your child. So it's very important to not wait till your child is 7, 8, 9, 10 years old. If you want rights to your child, file an action when they're a baby. File it when they're 1, 2, 3. When you get past 3 years old, you're getting in questionable territory as to whether or not that legitimation is going to be granted, whether the baby's name can change to your name and stuff like that. So anytime we have mothers who hire us and fathers are coming in 10 years later trying to do legitimation, yes, it can be denied. Okay, and I feel like I have, okay, got another one here. Fred says, What if the grandmother tries to take custody through false allegations? Okay, Fred, grandparents don't have rights to children. Grandparents who wish to have visitation rights should file an action for grandparent visitation or action for third-party custody. So a grandmother would absolutely get trumped in the event that you had rights to the child, and you would just need to know the appropriate steps to make that happen. But a lot of times we do have grandparent interference, especially if the parties aren't married. But you just need to know your rights and know them well. You take priority and precedent over a grandmother. Consultations with our office are $150. I will discuss that in 1 second. Got a little discount for you today for listening. Okay, Treveca Richardson, if your check is $600 a month and you have 2 kids, how much child support can they take out? Treveca, that depends. $600 a month is well below minimum wage. That's about minimum wage is $12.60 per month, so you're about half of that. So our child support worksheet actually looks at your income and the mom's income. So I really can't give you an answer to that, but I can tell you what, when they did if they were to run child support on you, they're going to put you in at least minimum wage. And so child support would be calculated on minimum wage and then the mom's income and then other factors that affect the kids, like if they're in child care or their medical insurance, that would go into the worksheet and then it would spit out a number that you would have a responsibility for. Here's Fred again. They call defects on the daughter with false allegations and currently have them. I'm ready to set up a consult. All right, I'm gonna put our phone number up in a minute, Fred. You can give us a call and we'll love to meet with you. Raquel Reynolds, what if the child is in another state? If the child lives in another state, then the action is gonna have to be brought in that state. If the father lives in Georgia and the child's in another state, Georgia can legitimate the child, but Georgia cannot determine the issues of child custody. So if the mother lives in the state and the father doesn't have legal rights, you can file where you are mom, if you're the mom of this child. Otherwise, you file where the child is. Okay, Diedrich, what happens if you're paying child support and children are not living with the mother? You may need to file a modification or go for custody of your kids. If your kids aren't living with you and they're living with someone else, they should be living with you, in my opinion. Have them pay child support to you. Okay. Brittany says, very often I hear people say they've signed a birth certificate and an affidavit of parentage when the child is born and should be legitimated. Can you explain the difference in signing an affidavit of parentage and actually petitioning the court for legitimation? Yes, in the state of Georgia, at the bottom of the birth certificate, if you've ever had a baby or been there when somebody had a baby, at the bottom of the thing it says like administrative legitimation, and a lot of people sign that and then it goes to vital records and you never see it again. That may give you legal rights, possibly, depending on when you signed it, meaning if you die the child can inherit from you, but it doesn't determine anything about the custody rights. You'll still actually at that point need to petition the court for determination of custody and visitation. Okay, Shannon, if the father makes $25K but has in savings and has a savings and inherited over $300,000. Shannon, I'm assuming this may be a child support question, but depending on how he's getting payouts on that inheritance, like if it's coming in an annuity fund or a monthly dividend or something like that, there's a possibility for it to be put in the child support. We'll need your income as well, run a child support worksheet. You can also set a consultation to come in for establishment of child support. How is child support handled? Yes, both parent incomes are considered. We're going to do a video on child support, so I want you guys to tune in for that when we do it, and we'll go over child support and how that all works. Okay, I think I now have gotten all the questions. If you have a question, type it really fast because I'm about to move on and wrap it up here. Okay. Okay. Okay, I'm going to take these questions really quick because they were typing really fast. Okay, the father is in Georgia and wants to file for custody, but the mother and child stay in California, so will he have to file in California? Yes, he will. And Shavonda have a claim in Florida and North Carolina. Shavonda, you need to seek out counsel in either Florida or North Carolina. Okay. So, thank you guys for tuning in today. There is so much more to discuss, so we'll be going live again probably next week. Keep your eye out for the date and time. Please share this broadcast with all of your friends. And if you would like to schedule an appointment to come into my office and receive personal advice, you can schedule a consultation. Consultations are $150. It gives you up to 1 hour with either myself or one of the other attorneys in the office. If you mention this broadcast, you can save $20 if you schedule your appointment on or before May 12th. That is a strict, hard deadline. May 12th will be the last day for the discounted consultation, and you must mention this broadcast at the time of booking, so that's a $20 discount. Hope you all have a great Friday. Happy Cinco de Mayo. Have a wonderful, blessed weekend. Thank you. Bye-bye.